Hello everyone, I'm George from Ireland, and in this video I'm going to ask what criminal law is about. Criminal law are about things that people do or things people refrain from doing, and which cause legal action to be taken against them by the state, and punishment will follow if you're found guilty. So criminal law is quite different from civil law. I mean civil law, I mean non-criminal law. Confusingly, civil law can also mean Roman law. So criminal law is very much a public law area because it's the state versus the individual, whereas civil law is usually the individual against the individual. Well, could be an organization against another, a private party, not the state. Not the state's not directly involved. So, because tort, for example, is a civil law area. Tort being wrong, if you think someone's done a civil wrong against you. So, now in criminal law, we're saying that the wrongdoing is sufficiently grave that the state is obliged to step in and take action against the malfeasant or the malefactor. Because this would have a negative effect on broader society if such conduct went unpunished. And even if the person who's the victim of the wrongdoing chooses not to pursue action, the state can choose to take action anyway. So in the United States, they've got a penal code which says what the criminal law is about. It says that it's about forfending behavior which unwarrantably causes significant harm to others or indeed to the common weal. It goes on to say that it's also about controlling people whose behavior shows that they are inclined to commit felonies. Furthermore, it states that the purpose of criminal law is to prevent behavior which causes others to suffer harm. Moreover, it's to warn people off doing things which are criminous. And lastly, it's to distinguish between misdemeanors and felonies. Felonies are grave crimes. Anyway, so let's look briefly at criminal procedure. So we have law enforcement agencies, mainly the police, and we have a whole administration of bringing people to justice. So law enforcement is principally about crime prevention. Prevention is better than cure. And so apprehending suspects, questioning them, so on, preferring charges against them, handing a file of evidence to the Crown Prosecution Service, who will then decide whether it's in the public interest to pursue their case or not. They may choose not a prosequi, do not prosecute, to ordering charges to lie on file, and so forth, presenting a case in a criminal court. So the proceedings, they vary dependent upon the severity of the offence allegedly committed. So some criminal offences are arrestable, others are non-arrestable, most of the former category. And the first category includes those which are the worst crimes. And that permits the suspect to be arrested without an arrest warrant. If it's something quite trifling, unless you catch them in flagrante delicto, the police require a warrant to arrest you sometime afterwards. But if it's murder, we could arrest anybody on suspicion of murder, even if we didn't have a warrant, and the murder was supposedly 30 years ago. So the Crown Prosecution Service, CPS, is the agency which is responsible for bringing these cases against defendants. So they have to weigh up the evidence and decide whether there's a sufficient evidentiary basis to warrant proceeding, and is in the public interest to go ahead with this or not. So they're not going to go ahead with things unless there's a significant chance of securing a conviction. That's why the conviction rate's pretty high, like 80% in England and Wales, because they'll only go ahead if they have a fairly convincing body of evidence. Incidentally, body of evidence, referring to the John George Hay case, doesn't have to mean a carcass. It means an amount, a totality of evidence of all kinds. Anyway, so there is a degree of discretion here. In one person's opinion, there will be a sufficient body of evidence to proceed in a certain case. That same body of evidence will be insufficient in the opinion of another person. So we are dealing with people here in the CPS, in the police, judges and so on. People are flawed and people vary, so they don't all have the same view of the same factual case. The CPS had to decide whether they should go ahead in the contentious case of Ireland, and it was not an easy decision to make, but we'll revisit that one later on. So we must realise that there are standards to be observed when deciding whether or not to go ahead with a case, and the CPS has to make a judgment call on this. Someone who's committed robbery might only be charged with theft if the CPS concludes that they're unlikely to get a conviction in relation to robbery. Difference is robbery involves the threat or violence or actual violence, whereas theft does not, simply snatching it without hitting on anyone or threatening to hit anyone. If you wounded someone, they might charge you with assault, saying wounding probably wouldn't get a conviction, but assault would probably shall. And wounding is a raised charge from assault. Assault is trifling by comparison. Someone who murders someone might only be charged with manslaughter, which is this unintentional killing of a human being, when not justifiable. So this is undercharging people. However, there are advantages to doing so, because these cases are easier to prove than the severer cases. Further, it might result in a guilty plea. If you plead guilty, then you are guilty, and they don't need to go to trial. So they're summary trials, which are not heard before a jury. They're faster, they're cheaper. If everybody contested things, the system would collapse. So some crimes are triable summarily, that's to say, with magistrates, no jury. Some offences are triable only on indictment, which is in a Crown Court, and there is a jury. And some offences are triable either way, could be before magistrates or could be in a Crown Court. Remember, Magistrates' Court, there is no jury. The great majority of cases, 98%, are in Magistrates' Court. It's a major offence if the person is standing trial in a Crown Court. So if a offence could be tried either way, then you can insist on having a jury. It's your right to be tried before a jury. This whole thing about juries being like the palladium of freedom is a bit overstated, because, as I say, the great majority of criminal trials in the British Isles are not before a jury. So anyway, so summary or indictment offences. To indict someone is to call them to trial before a jury. And there are different rules of procedure in the two sorts of courts. So once someone has been formally accused of a crime, the defendant, that's the person who's been accused, there's an indictment, which is saying what the accusations are. And this can be tried summarily, as I said, in a magistrate's court. So the indictment will say what the offence supposedly is, and include some details of the commission of the alleged offence and so forth. For example, Joe Bloggs is accused as follows, charged as follows: statement of offence that he committed theft, and then the particulars will say Joe Bloggs in October 2008 committed theft from Victoria Wine Shop and took 3 bottles of wine, something like that. So the judge and jury have distinct roles. The judge is almost like the referee, making sure that there's fair play between the different lawyers and the witnesses, but also he's saying what the law is. No, you can't say this, or that evidence doesn't exist, and so on, or you're not allowed to ask that question. But no, the judge is not deciding what the facts are. This witness says that she saw him steal the item. Is the witness telling the truth or not? It's not for the judge to say. That's for if it's in a Crown Court, it's for the jury to make up their mind. Going back to the well-known case of Ireland, a man named John Ireland. So John Ireland was accused of causing actual bodily harm, and the defence said a psychiatric injury which it allegedly caused was not actual bodily harm, but the judge was the one who's determining the law, said no, it is actual bodily harm, even though it's really mental rather than physical. So John Ireland therefore pleaded guilty. So there was no need to have a jury there. It was a Crown Court, because if he pleaded guilty, then he is guilty. Remember, a timely plea of guilty usually results in a 1/3 reduction in the sentence awarded. So the judge had to decide on a matter of law. Now, the defence could appeal the ruling. So if you're in a Crown Court, the case goes up to the Court of Appeal, and if the Court of Appeal allows the appeal, that means you're free. If they deny the appeal, no, then your conviction is upheld. Having failed in the Court of Appeal, you could then appeal to the Supreme Court. If they allow the appeal, then you're set free, and if they deny the appeal, you're still guilty. Your conviction still stands. I have simplified it slightly. Even if your appeal is allowed, you're not necessarily set free. There could be a retrial. Anyway, so that man, Ireland, he appealed, but his appeal was denied. So the jury are the ones who decide what the facts of the case are in a Crown Court trial. So they must decide whether they place credence in a witness's testimony and so forth, and what they make of evidence evinced by both the prosecution and the defence. So the judges to make sure that no evidence is adduced which is not pertinent to the case, or whether it does not have any probative value, is simply trying to befog the minds of the jury. So the prosecution and the defence are able to put their cases to the jurors. The judge will provide a summing up, and he or she might try to nudge the jury one way or the other. That's considered permissible, but it's up to the jury to vote whichever way they wish, which could be totally against the wishes of the judge, and the judge is bound to go along with that. Although the judge can direct the jury to find people not guilty, in which case they are not guilty. I mean, having directed the jury to find someone not guilty, I don't know if the jury have to say, okay, we do then. Because could they actually say, well, we're disobeying you despite you directing us to find him not guilty? If the judge directs a non-guilty verdict, then that is the verdict is not guilty, but that's highly unusual. Contentiously, it happened in the Stephen Lawrence case in 1994, since Stephen Lawrence was the murder victim, not the defendant in the first Stephen Lawrence trial. So if there are any questions of law which need to be cleared up, it's up to the judge to explicate that to the jurors. They're laymen, laywomen, ordinary members of the public who are on the electoral register, who cannot be lawyers, and they are put there to hear the case and vote guilty or not guilty. And remember, they're used in criminal trials. They're only occasionally used in civil trials in England and Wales if it's a case of libel. The judge also has to inform the jury that it behoves the prosecution to prove their case. The onus of proof is on them. It's not for the defence to prove their case. So Joe Bloggs is charged with murder. It's up to the prosecution to prove that he did commit murder. It is not for the defence to prove that he did not commit murder, because proving a negative is almost impossible. Can you prove that you've never stolen anything? You can't. How could you possibly prove that? So the jury will be directed by the judge. However, if he misdirects them, then he's erred in law, and you can have an appeal on that basis. So where does criminal law come from? So there's common law, and there's law which are made by judges. Murder and manslaughter are common law crimes, not defined in statute, but most criminal offences are described in statute these days. So things were often common laws crimes that were just recognised as crimes for many centuries, but later they're put into statute to make it crystal clear, such as theft. There's a Theft Act, various crimes of violence. The Offences Against the Person Act is the operative act from 1861. Now, statutes don't always describe the common law offence in its totality. So common law still has some role to play. Remember, in Ireland, that case, the statutory offence was one of causing actual bodily harm. But could this include mental harm? And the court found that it could. So European law and the European Convention on Human Rights are also critical here, even though the United Kingdom has departed the European Union. So you must bear in mind that the European Convention on Human Rights has had a major influence. So almost all the time, laws are challenged on the ground that they are not compatible with the Convention. So an obvious case would be Dudgeon and the United Kingdom. So this is about 1980 in Northern Ireland. Homosexual men were getting up to their intimate activities in Northern Ireland, and that was still unlawful in Northern Ireland. And it was alleged that this was depriving them of their articles under their rights under Article 8 of the ECHR. Anyway, there was another case, A, against the United Kingdom, when there was a defence of reasonable chastisement. So there was a stepfather, he caned his 12-year-old stepson, and was he allowed to do this? Right, and actually it turned out that he was under Article 3, right, respect for family life. So Parliament then amended the law to say you can't hit your children like that, and that your homosexual relations are permissible in Northern Ireland. So although the UK is out of the EU, as I said, the European Convention on Human Rights still applies. That predates the EU. So what else should we bear in mind? Well, that's maybe just a very brief introduction to the to what criminal law is. Toodaloo.